From the very beginning, our side has been insistent that this matter must be handled very carefully and with utmost caution and care for the victims. We want maximum transparency. We have always been about that. We want every single person who had any scintilla, there's any scintilla of evidence that they were involved in the Epstein evils, they need to be brought to justice, and it should have been done a long time ago. We need to find out who those people are. But in the meantime, you have to remember there are real people's, innocent people's lives at stake here, and young victims who don't want to be dragged into this political game because it could hurt further what they've already endured. They would be made to suffer more harm if Congress is not careful in what we're doing. And unlike our very important work that's underway in the House Oversight Committee, the Democrat-led discharge petition would carelessly dump thousands of documents without proper protections for the innocent. I brought a chart in here this morning. I want to illustrate for you what we are concerned with. Now, I was a federal court litigator. The members of our House Judiciary Committee, Republicans in particular, have many of these concerns. You have Chairman Jim Jordan and attorneys like Chip Roy, who's running for Attorney General of Texas now. You have Brad Knott, who's a former federal prosecutor, many members on the committee. Andy Biggs is running for governor of Arizona. They're lawyers, and they understand that the way the discharge petition was drafted is haphazard and dangerous. This is why we have been opposed to this point, okay? And I could be here for a long time going through all the details of it, but the big concern we've all had all along is that the House bill, if it's passed in its current form and it was signed into law, it is dangerously flawed. And our problem and our frustration is there's no way for us in the House to amend it or correct these problems because the authors of the discharge will not allow it. And that's one of our great frustrations. Let me just very quickly, we have a legal document that the lawyers, we have all drafted to explain all this, but let me give you five quick, maybe the top 5 concerns about it, and there are more. But as drafted, the discharge petition, it fails to fully protect victim privacy. I'm going to read you an excerpt out of our legal document we put together to explain all this. Congress should give the Attorney General broader authority to redact all the victim information. The discharge doesn't do that. This would prevent the release of information that could be used to unmask victims who have chosen to remain anonymous. Now, you have some very brave women who have come forward and put their names and faces out there and done press conferences and explained that justice is overdue, and our hearts go out to them, and they are heroes. But you have as many as 1,000 women, by some of the accounts, who may be caught up in this. And the vast majority of them have not come forward, probably for obvious reasons. They don't want to be unmasked. But the discharge petition doesn't have adequate protections. It risks re-victimizing those who were trafficked and exploited. And the courts have recognized this concern, by the way. I'll read you a quick excerpt. On August 20th of this year, Judge Richard Berman, the Southern District of New York, issued an order denying the DOJ's request to release Epstein grand jury materials, noting, quote, names and identifying information of victims appear in the subject materials, unquote. Judge Berman then quoted a letter related to the victims' concerns, which stated the following, quote, transparency cannot come at the expense of the very people whom the justice system is sworn to protect, unquote. And importantly, the judge quoted a letter from one of the victims. In the proceedings, she is named as Jane Doe 2. She said this is one of the victims, quote, I beg the court to make sure it is of the utmost priority that in any sort of release, all and every detail that could possibly reveal our identities be redacted. The victims of Epstein's evils deserve that protection, and the discharge does not currently provide it, okay? Number 2, the discharge petition could create new victims, okay? Because it requires the DOJ to release information even in cases where the DOJ or the FBI has already reviewed it and determined it is not credible, it is false information. Doing this and requiring this to come out could ruin the reputations of completely innocent people, such as those who have may just have known Epstein but knew nothing of his crimes, or whose names he exploited. Think of this, innocent people whose names he exploited and used to try to get close to his intended victims. Their names may be in these files, and they had nothing to do with this. And so by just haphazardly releasing it, you're going to destroy their reputations. Releasing information containing the names of innocent people would subject those innocent people to a guilt by association. It would create an entirely new group of victims who have no means to clear their names. That's a concern of Congress, and it should be. It should be. Number 3, the discharge in its current form fails to prohibit the release of child sexual abuse materials. That is a term of art. It's called CSAM, okay? It's defined in the U.S. Code. The discharge is so haphazardly written because, remember, it's just a political exercise for these guys. They don't seem to care about this, but they cited the wrong section of the U.S. Code. So when they say that we don't want child pornography to come out, child sexual abuse materials, of course, we don't want that released. They wrote this thing so quickly that they cited the wrong section. So you know what that means? It means that it doesn't really bestow any real legal authority on the Attorney General to redact those materials. And that would compel the DOJ to release that stuff into the public. Every single person in this room knows that's wrong, and you should stand against it. But that's what the discharge says. Number 4, it jeopardizes the future federal investigations of the United States. Why? Because the discharge only allows the Attorney General to redact limited portions of records that could publicly identify individuals who are promised confidentiality. In this scenario, you're talking about whistleblowers, you're talking about confidential informants who came forward and gave information and evidence in exchange for agreeing to have their identities not revealed. Violating confidentiality, imagine the chilling effect that would have on future investigations. Who's going to want to come forward if they think Congress can take a political exercise and reveal their identities? Who's going to come talk to prosecutors? It's very dangerous. It would deter future whistleblowers and informants. And the release of that could also publicly reveal the identity, by the way, of undercover law enforcement officers who are working in future operations. Dangerous stuff, and they seem not to care. And by the way, I'm going to remind you again, we went to the authors. We asked the authors of the discharge to change this, and they said jump in the Potomac, all right? Number 5, national security concerns, okay? The discharge requires the Attorney General to release within 30 days, quote, classified information to the maximum extent possible. This ignores the principle that declassification should always rest, and always has rested, with the agency that originated the intelligence. Why? So that they can protect their critical sources and methods. It is incredibly dangerous to demand that officials or employees of the DOJ declassify materials that originated in other agencies, in intelligence agencies. I could go on. I won't be here all morning, but there's a lot of problems. There's also a lot of legal scholars, and I'm among them, who are concerned that that you've got problems with grand jury secrecy. We know Rule 6E of the Federal Rules of Criminal Procedure prohibits the release of grand jury materials, but the way the discharge is drafted, you can make an argument that it requires all that to come out, and that is a serious problem. Grand juries are not adversarial, okay? There's no opportunity there for cross-examination. You can't disprove evidence. You can't challenge the evidence in any way. And if Congress goes in and breaks that seal and just starts releasing sensitive grand jury materials and allegations like that, it raises a risk that the grand jury process will be politicized in the future. And that's a whole other danger that we could talk about all day. I'm gonna wrap this up and just say that Republicans support maximum transparency. We always have. The President of the United States supports maximum transparency. You've heard him say it in his own words. But he has had the same concerns that I've just articulated here